Sveicināti atkal. Mēs turpinam semināru ar tā trešo daļu.
Hello again. We continue our seminar with the third part. It's going to be a discussion. I give floor to the Mrs. Woods.
Thank you so much, and welcome back. Now we are going to have our panel on a question that has been before the courts in the various jurisdictions represented here for many, many years, not only, of course, in these jurisdictions, but around the world. That is the liability of an internet service provider for copyright infringement. And we will be having a discussion focused around a judgment of the Court of Appeal in Lithuania with commentary by two other distinguished experts giving national perspectives and their experiences. Going to go right into this, and we'll have the presentations, and then we will have time for questions and comments. So everybody be thinking about questions and comments, because that's often the most interesting part, engaging in that way for the speakers. So without further ado, let's go to the presentation from the distinguished judge from the Supreme Court of the Republic of Lithuania, Judge Goda Ambrasaitė-Balynienė, who will be telling us about the Linkomanija case for about 20 minutes. Please go ahead.
Thank you very much, Michelle. I cannot start my presentation, of course, without first of all thanking the organizers of this event for giving me the opportunity to be here with you, even though online. I'm very happy with that. Now I will try to share my screen. Is it okay? Can you see my slides? Yes. Yes, very good. So, as Michelle already mentioned, I am going to shortly present you the Linkomanija case. The judgment on this case can be found in WIPO Lex-Judgment database, the judgment of the Court of Appeal in this case. To start with, Linkomanija case is interesting for several aspects. First of all, it was the first case in Lithuania where the internet service providers were asked to block access to the copyright infringing website. It was the first in Lithuania, and till the moment it is still the last heard by civil courts, as we have now another procedure under which such injunctions can be obtained. But of course, as Michelle clearly stated, it was not the first case around Europe. So another interesting issue with this case is that in this case, the parties have relied on, and the courts have also considered, not only the relevant explanations of the European Court of Justice, but also some judgments of other jurisdictions. So probably I should start by shortly explaining what Linkomanija is, because some of you probably never heard about it. Linkomanija is a BitTorrent file sharing service. To put it simply, the mechanism of functioning of this website is the same as that of Pirate Bay, which probably you all have heard about. At the time when the case was started, it was the Lithuania's most popular torrent index and 18th most popular site in the country. It was quite broadly known in Lithuanian society as basically designed for the illegal sharing of copyrighted content. According to the Lithuanian Copyright Protection Association, LATGAA, in 2016, when the Linkomanija case was started, the website contained more than 100,000 illegal files. And as it quite usually happens in this type of legal disputes, the website itself was once created by a Lithuanian national, and it was till the very end mostly Lithuanian. However, when the case was started, the website was registered on behalf of Vitality International. That is a company registered in Seychelles. It is also interesting to know that in 2012, in another case, which was started against Linkomanija by Microsoft company, Vilnius Regional Court has ruled that the transfer of management rights to Vitality International in 2009 was in fact a fictitious act. However, this case was later on ended by amicable settlement on appeal, so these judgments have never come into force. So LATGAA has started its blocking attempts against Linkomanija in 2016, as I've told, by filing a suit before the Vilnius Regional Court and demanding that several local internet service providers prevented their subscribers from accessing Linkomanija website. This claim was based on the Article 78 of the Law on Copyright and Related Rights of Lithuania, which in fact implements the relevant provisions of InfoSoc directive that allow for the possibility to seek for an injunction against intermediary whose services are used to infringe copyright. The problem here is that, as you probably most of you know, the directive itself granting the possibility of such an injunction gives very little guidance as to specific conditions or even more the procedures which should be followed in order to grant such type of injunction. Actually, the directive clearly states that the conditions and modalities relating to such injunctions should be left to the national law of the member states. And as it often happens, our special law, that is the law on copyright at the time, contained absolutely nothing more than the directive itself. So there were no specific conditions or procedures under the law on copyright and related rights as well. So the defendants in this case, they presented a vast amount of arguments why such an injunction should be refused by the courts. And for the sake of clarity, I have grouped them into the 5 very general questions. That is, who are you? Why us? Where are the others? Is it proportionate? And last but not least, who is going to pay for that? And this last aspect was actually the only aspect where the courts of first and second instance disagreed. So speaking about the first group of arguments, the defendants first of all tried to say that the claimant has no locus standi for this type of injunction. What the defendants were trying to say that if you want to get the injunction such as this one, that is to block the entire website. So first of all the content of this website must be copyright infringing. And you, as the collective association, the claimant, must represent every single author whose works are made available on the Linkomanija website. The courts indeed refused that argument by saying that for the locus standi, it is absolutely enough that the claimant represents at least one author who is affected. And the precise content of the Linkomanija website should be assessed in the scope of the principle of proportionality. That is by hearing the case on the merits, but not by deciding whether to accept the claim or not. Of course, the defendants also tried to convince the courts that they are not intermediaries in the sense of this particular provision, insofar as they have no contractual relations with either the Linkomanija operator or the host of Linkomanija website. And because there is no evidence that at least one internet user, the client of the relevant ICPs, have ever, in fact, accessed Linkomanija website. Again, the courts dismissed this argument actually by stating that absolutely similar arguments were dismissed by the European Court of Justice in the Telekabel case. Going to the next group of arguments, the defendants, first of all, draw the attention to the fact that the claim was directed only against several local ICPs, that is, against 9 biggest ICPs in Lithuania, when at the time there were around 100 of active ICPs. So what the defendants tried to say here, that such a selective injunction against only some ICPs, if granted, will violate the rules of fair competition, because other ICPs who are not under obligation to block Linkomanija website will be in more good competitive position. Again, the courts disagreed, and they said that under the general procedural rule, which is also applicable in this type of cases, the right to choose the defendants is actually on the claimants. And the only situation where the court can say something in this respect is the situation of mandatory procedural complicity, which is not the case here. And as it is not the mandatory procedural complicity, the claim cannot be dismissed solely on the reason that not all possible defendants were included into the claim. Further on, the court stated that according to the EU law, internet service providers have a duty to cooperate in the fight against copyright infringement. And this duty cannot be avoided by simply stating that someone else is also acting illegally, that is not complying with this obligation under the EU law. It is interesting to say that probably the next day when the judgment of the Court of Appeal has been passed, Tele2, one of the internet service providers, quite quickly growing internet service provider, which was not, however, included in the claim, announced publicly that the company will block Linkomanija website voluntarily, irrespectively of the fact that there is no court decision against them yet, because as the head of the company explained, the position of the court is absolutely clear and unambiguous, and they are not waiting for the separate proceedings against them. Probably the most interesting and problematic question in this case was, who are the persons concerned? Who are the persons concerned? Who has to be given the right to be heard? Speaking more concretely, in more particular, must the operator of Linkomanija website be afforded the right of audience in such type of proceedings? Some defendants even said that actually all the internet users must be included into the case, as their right to access to information is somehow under dispute. Well, this question was not far from easy to answer. Of course, we can say that the operator of infringing website is someone whose rights are in some kind affected by the blocking injunction, at least if we speak about the situation when such an activity is at least partially commercial, which was the case with Linkomanija. Due process of law requires that all the persons concerned were given the opportunity to present their case before the court. There might be some exceptions, and we have them in Lithuania as well, and they are possible under TRIPS agreement for provisional orders. But the injunction sought here was not indeed a provisional order. On the other hand, one can pose a question, so why do we need injunction against intermediary at all if we already have our hands on the operator? So why do we need this specific measure in the directive? So even before the Linkomanija case was started, some European court, for example, the District Court of Hague or High Court of Justice of the United Kingdom, have already expressed the position that actually there should be no such jurisdictional requirement as to join or serve the operators in this type of proceedings. Why? Because different interpretation would render the regulation of orders against intermediaries absolutely meaningless. Because the very basis for such a specific legal measure is that the operators of infringing website are sometimes inaccessible because they are somewhere outside the EU jurisdictions, or their identity is simply not known. So that's why it is inherent in such regulation that an order can be imposed upon intermediary in proceedings to which the alleged infringer is not, or at least not necessarily, a party. So Lithuanian courts have followed this position, and what the court said, that where the circumstances of the case allow us to be concluded that the operator of the infringing website deliberately conceals information about himself, neither the claimant nor the court seized shall be required to search for such an operator. On the contrary, the operator of a website who makes his contact details inaccessible must bear all the risk involved, including the possibility of imposing appropriate injunctions without first hearing his positions on the matter. One of the central questions, as I've mentioned, of course, was the proportionality of the injunction sought, which contains such elements as suitability, necessity, and so-called proportionality stricto sensu, that is how much we interfere with other rights protected by the Charter. So first of all, the defendants were stating that such type of injunction is actually not effective. And insofar it is not effective, it is not proportionate. Well, this argument is probably the most popular argument. As far as I know, it has been used in every single proceedings against internet service providers everywhere. So we all understand and we all know that every blocking injunction can always be circumvented, always. And internet pirates are not those whose understanding about how to do that is very low, no. So what conclusion can we make? If the courts would adopt this so-called absolute effectiveness requirement, absolute effectiveness standard, that would mean that such kind of injunction would never be justifiable. And this measure provided by the legislator would be just a fairy tale, something which cannot be applied in practice. That's why in the LATGAA case, the European Court of Justice has chosen the reasonable effectiveness standard by saying that it's not actually necessary that the access to the infringing website would be absolutely precluded. It is enough that such access is made more difficult, or such a measure seriously discourages internet users. The same position was supported in Pirate Bay case, especially by the Advocate General, who also drew attention to the fact that more effective measure, that is the blocking of all internet traffic, has been already considered by the European Court of Justice and rejected. So if now the measure that is less restrictive was rejected on the ground that it is not sufficiently effective, then at the end, internet service providers would in fact be released from their duty to cooperate against copyright infringement. So this is the line which was also followed by Lithuanian courts in Linkomanija case. Speaking about necessity, the defendants tried to convince the court that actually such a measure, injunction against internet service provider, is ultima ratio measure. Ultima ratio measure which is only possible after the claimant have tried to sue the operator and was unsuccessful, and secondly have tried to apply to the host of Linkomanija website and also was unsuccessful. When the claimant, on the other hand, felt that it is just an alternative, so the claimant is free to choose which kind of measure he wants to take in a particular case. Again, it is not so easy question. If you look into the InfoSoc directive, one could say that it is a simple alternative, because the directive says that such type of injunction can be obtained without prejudice to any other sanctions or remedies available. But on the other hand, what about the proportionality, which requires us that we must consider other less restrictive means that are capable of producing the same result? So the courts took very careful position in this respect. Speaking about the claim against the operators of the infringing website, the court said that yes, in principle, in order to justify the proportionality of such a measure, the claimant must show that he at least try to direct his requirements against the operator of the infringing website. Why? Because if it was possible, if such a claim could be successfully brought before the court and the judgment executed, then it would be more effective and less restrictive of other rights protected by the Charter, and therefore should be given the priority. However, on the other hand, the claimant cannot be required to take excessive, costly, or very time-consuming procedures in order to identify the operator of the infringing website and to bring an action against him. In the event that the operator of the website in suit fails to cooperate, it is difficult to access or identify, for example, because it is established outside the EU jurisdiction, the claimant cannot be deprived of direct access to this particular remedy. As regards the notice and takedown by the hosts, the courts actually said that no, the claimant is not required to do that, because this measure was considered by the court to be less effective than injunction against the internet service providers. Speaking about the right to information and freedom of expression of internet users, of course, Linkomanija, as many copyright infringing websites, contained also part of totally legal information. So the question here was when the court can block the whole website. The answer of the court was that in order to recognize that the need to protect the rights of copyright owner outweighs the right to information and freedom of expression, in a particular case, the court must be provided with sufficient evidence that the scope of infringement is sufficient to justify blocking. And in this respect, such circumstances as the type of information which is shared in the website ensued, methods of activity of this website, and the position of the website operator are important. In this case, the court decided that, first of all, Linkomanija operator is trying to make his contacts inaccessible. There is absolutely no means how the copyright owner could access the operator and ask to remove some copyright violating content. And the website was at least partly commercially based. So the courts decided that in this particular case, it is enough to conclude that the scope of infringement is sufficient to justify blocking in this respect. As to the freedom of business of internet service providers, the courts first of all draw attention to the position of ECJ again in the telecable case that injunction that does not specify the specific measures which that access provider has to take is not as such precluded. And it was exactly the case. The claimant was not asking for any specific type of blocking. He left the specific means to be chosen by the internet service providers. In the opinion of the courts, the defendants in this case have failed to prove that any measure, any blocking measure would result in excessive costs. And also they took into account the fact that under the national law, the defendants already have an obligation to block certain websites, for example, the illegal gambling websites. So that means that they should have necessary means for doing that without any additional investment.
So you've got another minute or two?
Okay, I'm going to end. So this is the last question where, as I have said, the courts have disagreed. Who is going to pay? Who is to bear the compliance cost? The first instance cost was of the opinion that the compliance costs should be borne by the claimant. And this reasoning was based on the fact that the defendants themselves are not infringers and they only provide technical means. So they should not imply such additional cost for doing that. In fact, very similar reasoning was given by the UK Supreme Court in Cartier International of 2018. This judgment was, by the way, presented to the Court of Appeal by the defendants by trying to support this particular position of the first instance court. Well, on the other hand, the claimants presented numerous judgments of numerous jurisdictions stating totally to the contrary, that the compliance costs have to be borne by the defendants in this case. So the Court of Appeal has ruled, and this position was later on supported by the Supreme Court, that first of all, from the point of view of EU law, both ways are possible. The way that the claimant bears the compliance cost and the way that the defendants bear the compliance costs. The national court in a particular situation is obliged to assess the distribution of this cost under the principle of proportionality. The court went further by stating that unlike the court precedents in UK, on which the Supreme Court judgment of the UK was based, Lithuanian national law contains no exception from the general rules of allocation of enforcement costs in case of application of Article 78 of the law on copyright. Again, the defendants have failed to prove that in this particular case, the compliance costs will be disproportionate and that there is a need to establish proportionality by a partial or full assumption of the cost burden by the right holders. And last but not least, the claimant in the present case is not a business entity, which was the case with Supreme Court judgment in the UK. It was a trademark case. But a non-commercial collective copyright organization. So we cannot attribute such costs for normal everyday business costs of the claimant. So that was my last statement. I hope I'm not over my time, and I'm looking forward to our discussion.
Great, thank you so much for that really clear explanation and really interesting case. We do have one question I thought I would pose to you before we move to the next speaker, at least to answer in a brief way. If there's something more extensive, we can pick it up later. But the comment is, the presentation was great. What kinds of proof of illegal content was submitted to the court by the plaintiff? Is that something you can answer?
Yes, absolutely. Actually, the claimant made a presentation during the court session at the first instance court. So he accessed the Linkomanija website and showed to the judge what kind of information is stored here, and showed some examples, one movie, one book, one other copyrighted content. So the courts considered that it is enough to see that most information was copyright infringing. And of course, it is also not to be left aside that Lithuania is quite a small country. So such a popular website as Linkomanija, about which the information is all around in all the internet sites, was also available to the court and also presented.
Great, thank you very much for that quick response. Now let's turn to our next speaker, another distinguished judge, this time from the head of the IP division in the Regional Court of Warsaw, Poland, Judge Agnieszka Gołaszewska, to present a Polish case on host provider liability for copyright infringement. Agnieszka, over to you.
Thank you very much. And firstly, thank you for invitation, being here. And it is a great pleasure and privilege to be able to share my case with you, with all of you. So firstly, I'd like to share my screen with you. I will try to do that now. Yes. Okay.
So maybe, do you have two screens? Yes. Yeah, that's better.
I got it.
Perfect.
Okay, thank you. So the case I'd like to present today is quite well known in Poland and quite famous, because actually it was the first case about the liability of hosting service provider, and it has not been finished yet, because today we will be discussing talking about the judgment of the Court of Appeal in Krakow, and it was given in September 2017. But one of the parties, I mean the defendant, brought an appeal against that, and we are waiting still for the judgment, the final judgment of the Supreme Court, because the case now is moved to the Supreme Court. So firstly, I'd like to look shortly to the facts of the case, later legal grounds, later the judgment itself, and finally I prepared a short comparison between this case and the Lithuanian case described by Judge Ambrasaitė-Balynienė. So firstly, the facts of the case. We get 4 claimants, both collective management societies as well as copyright holders, for the certain movies, 3 certain movies quite popular in Poland. And we get the defendant. And the defendant was a hosting service provider running a platform available on the internet under a certain website. And the recipients of the service, of the hosting service, could create their accounts and store the files with the contents, and exchange the files with the content, and share the content with each other. But the role of the defendant was not a passive role. Actually, the defendant was quite active in these proceedings. If the file was big, if it exceeded 1 megabyte, it's transferred from one interested user to the next, from one account to the next account, required active cooperation of the defendant. So the role of the defendant was not only storage of the content, but it was an active role. And some of the content was transferred free of charge from one user to the next. But upon transfer, for example, big files, including movies, mostly movies, the defendant required previous payment, and this payment was collected by the defendant itself, not by the copyright holders or collective management societies. And about 90% of the content was infringing content. Movie songs were disseminated without the consent of the copyright holder and without the payment, without the agreement. So it was an infringing content. When we talk about the legal grounds of the case, I'd like to focus on Article 14 of so-called e-commerce directive. So it is a limitation of liability of hosting service provider. So that hosting service provider is not liable for the copyright infringement if it has no knowledge of illegal information and the illegal character of the content disseminated in the platform. If the provider, upon obtaining such knowledge or awareness, acts to remove the access to the information and to the infringing content. It is the provision that brings a kind of balance in this liability, because on one hand, the hosting provider presents to the public the content, but on the other hand, the content does not come from the hosting service provider, but comes from the recipients of the hosting service. So this kind of balance of the liability is very much needed. And now let's skip to the judgment itself. What the Court of Appeal in Krakow decided in the case, quite famous case, in September 2017. The defendant was declared to be liable. Why? Because defendant was an active player. Its service was not only limited to the storage of content, but in many cases, its actions were decisive for the transfer and the dissemination of the infringing content, and thus the defendant consequently cannot benefit from the liability limitation of Article 14 of e-commerce directive. And what was more, the defendant didn't react properly when being notified of the infringements. So in most cases, in fact, actually no actions were taken by the defendant. There was no reaction. And the defendant has been compelled by the court to check for 3 years if the internet search engine shows infringing copy of these 3 particular movies on the website operated on this platform, and if so, to remove both the copies and the user accounts used for the dissemination of the copies. So it was, as I said, quite famous judgment. In fact, first probably in Poland regarding this subject. And now we are waiting for the judgment of the Supreme Court, and the oral hearing in the Supreme Court was postponed because previously it was planned for January this year, but it was postponed because our Supreme Court wanted to wait for the judgment given by the EU Court of Justice. And this judgment was given by the EU Court of Justice on 22nd of June this year in joint cases. You can observe the number of the cases in the presentation. The Court of Justice explained quite clearly in this judgment what does it mean when the role of hosting service provider is active. And what the Court of Justice said that it is important when if the hosting service provider has knowledge that the protected content is available illegally on the platform and refrains from deleting it or blocking access to it, and refrains from putting in place the technological measures that can be expected from a reasonably diligent operator. And the third situation is the most obvious one when the hosting service provider provides tools on its platform and dedicated specifically for illegal sharing of such infringing content or knowingly promotes such sharing. It's quite obvious. So we are looking now for the new date of the oral hearing of the Supreme Court, but probably I I think that there is a great possibility that the judgment of the Court of Appeal of Krakow will be upheld, because in fact, and the attitude accepted, the attitude taken by the Court of Appeal in Krakow in this judgment of September 2017 was very similar to the one taken by the Court of Justice in the judgment of 22nd of June this year. And now, to finish, some general remarks, short of very quick comparison between this Polish judgment and the Lithuanian judgment. I guess that we can observe in both judgments a kind of similar approach and philosophy. I mean, both internet access providers, like in the Lithuanian case, as well as hosting service providers, have some obligation to contribute to eliminate online copyright infringement. And the second thing is, the more active steps are taken, the more active you are in dissemination of infringing content, the more active steps and the more costs are required from you to eliminate the online infringement of copyright. And the last remark I'd like to point out, to focus on a difference, because in Lithuanian case we have a kind of general approach because it was blocking access to the website, while in Polish case kind of individual approach, because it was about using searching engines to identify particular content and to remove the accounts of particular users. But I guess that this final difference is the consequence of the different role of internet access provider and the hosting service provider. So thank you very much. It was a great pleasure to be here and waiting for the discussion. Thank you once more.
Thank you so much, and particularly for going ahead and doing some of that comparison for us. I think that's very helpful both to us and, of course, to the audience. So we'll just see whether there's any quick question or comment. Don't see any in the chat right now, so I think we can move on to our final presentation and then come back to have a little more discussion among the three of you, as well as with members of the audience. So our third presenter will be Dr. Richard Gulbis from the Latvian Supreme Court. He is the deputy head of the working group for the improvement of the copyright law. So certainly very timely in this case. And he is going to talk to us a little bit about the Latvian experience dealing with rights holder requests to order ISPs to block websites that have allegedly have pirated content. So Richard, over to you.
Hello, dear participants of this seminar. Thank you very much to the organizers for this kind invitation to this discussion. I was very interested to listen to the presentations of Lithuanians and Polish. And in Latvia, we also face similar issues. And I must say that similar to the colleagues of Lithuania and Poland, we have one court case, only one. And in this case, we were thinking about responsibility of the mediator. And unfortunately, I must say that in this case, only the first instance court made the judgment, and this case didn't get to the Supreme Court because the second instance court judgment wasn't appealed. So unfortunately, we didn't have a vision of the Supreme Court how to solve such cases. But let us try to look at the main arguments the court mentioned justifying why this request was refused. So this is a difference. So in this case, this was refused. This claim was refused. So the owners of the rights, so those were licenses to movies, and the claim was against two ISP server providers. And the subject is to block access to this pirate internet site where those films were distributed without permission. And the evidence that other works in that site would be also illegal, those claims were not submitted. One big difference from Lithuania and also from Poland example was that in this case, between the parties, there wasn't a real dispute. Also, the court established it. And so opposing what was said by Lithuanian colleagues, that there were a lot of arguments against the applicant, but here against the application, but in Latvia's case, there were no. So both defendants straight away acknowledged the claim. And the goal wasn't to solve the dispute because there wasn't a dispute between the participants of case, but the goal was to see whether in the civil order it is possible to see whether it's possible to block the internet provider, internet sites. And this was an artificial, actually, litigation. And the fact that it was an artificial litigation, it actually burdened and made it more complicated for the court because there were no real disputes between the participants and the parties which are necessary. And so from my point of view, in this case, the litigation should have been terminated, but the court examined the case on its merits and also both instances refused this claim. And why? Why? The court puts emphasis on the question about proportionality principle, and also emphasized the need to have a balance of the basic rights between the users of those internet sites and also holders of sites and owners of the intellectual rights, copyrights. And in order to maintain this principle of proportionality, first of all, they had to go against the perpetrator, or alternatively, it was had to be proved that his protection of his rights is not possible. And this is in line with what was said by a Lithuanian colleague who said that as far as I understood, that there was not contact information available and so on. So in this case, there was a little bit different situations. The contact information was available. There was also the holder of the internet site had also published the way how the owners can request to exclude the content from the internet site, but this type of procedure wasn't tried out straight away. The claimants went to the court. And looking at this balancing principle and principle of proportionality, the court considered that it wasn't done, that first of all, they had to turn to the holder of the internet site. And the second instance, which examined the appeal, they also emphasized the proportionality principle and said that it wouldn't be proportional to limit access to the all content. Before that, not carrying out the measures which would stop this kind of infringement. And also said that the applicant knew the procedure, how to turn to the holder of the internet site and protect his rights. So those were the main arguments. And so the emphasis was put on the proportionality principle and the principle of the balance of basic rights, and also, first of all, to turn to the person holding the internet site and to go through this procedure, or there should be some kind of evidence that this kind of procedure is not effective or wouldn't be effective. An additional circumstance, which was also raised in the appellate court, that the case was about two specific films and wasn't information whether the other content also infringes something. What was unanswered, we didn't get the answers through this litigation, whether in such cases there is a need to turn to the court, because both defendants said that without the court decision, court judgment, they couldn't block the access to a specific internet site. And they justified their position with network neutrality regulation 2015. And still, they ignored the condition that a regulation has an exception that this content can be blocked in the case when it is necessary for the implementation of legal acts of the EU, also related to the copyright. So this argument, at least for me, is not assuring. So why, in the situation when both defendants agree with the claim, they needed to turn to the court and try to solve this case through the court? Also, I need to keep in mind the circumstance that the mediator from the one side is interested to ensure the access as broad as possible to the resources for his subscribers. But on the other side, as this case proves, that both mediators were also the disseminators of the content. And in Latvia, the practice is that disseminators of the content and retranslators are more active in the protection of rights than the initial owners of the rights, because they are interested in the fair competition in the market, which is very good. But at the same time, it raises a question. So how objectively they assess those requests to block one or another internet site. And in the end, I also wanted to say that in Latvia, we have a little bit started discussing about the possibilities to give this function to block something to the public institution, because also there is a similar experience with not allowed retransmitting and also the lotteries and blocking of that. But it is possible, and if it is done by the public institution, state institution, and if the state gets finances, then for this decision making, all the requirements in the telecom judgment from the EU is binding, and also the requirements for the principle of proportionality. So this is in short about the situation in Latvia, but now I looked in the court systems, I don't see any new cases in relation of this. Maybe I missed something, but generally I don't see.
Great, thank you so much. And this has been really interesting, and interesting to finish with a slightly different situation of a case where the injunction was not granted, and to hear some of the factual circumstances that appear maybe to have led to that result. So Before we wrap up, we did have one more question that was actually related to Goda's presentation, but I think maybe one that all of you could consider in your own context, your national context. And this, the question was whether there should be a more detailed regulation in the Lithuanian copyright law.
Well, actually, we do have many changes since Linkomanija's case was heard. And that's why I said at the beginning of my presentation that it is insofar the last case heard by civil courts. Actually, in November 2018, we had a relevant amendment of the law on copyright, which grants, as Richard was speaking about, the possibility to grant the blocking injunctions to Radio and Television Commission. If this is a simplified procedure, and the Radio and Television Commission can do that with the sanction of Vilnius Regional Administrative Court, which has to give a relevant sanction in 3 days. Well, there was some discussion between the civil judges whether such an amendment was really well taught, because first of all, administrative courts never dealt with copyright issues before. And also looking into the complicity of Linkomanija case, which lasted 3 years, by the way, some judges were wondering whether it is at all possible to give such a sanction in 3 days. So, but if to speak about the statistics, during the first year after the relevant amendment came into force, actually there were more than 70 websites blocked by the Radio and Television Commission. So it is very, very effective in this respect. But we have no analysis made on the principle of proportionality and so on. But another important amendments which relate also to Linkomanija case, which were made. For example, now the law clearly establishes the presumption of illegality of the content. So when the Linkomanija case was heard, it was not the case. So that's why the defendants were saying that you have to prove that every single piece of work that is contained in Linkomanija is illegal. And in Linkomanija, the courts actually say that, well, if we don't have information that the creator have given the consent of publication, so we presume that it's illegal. But it was the position by the court. It was not included into the law. Now we have a presumption in the law that in this type of cases, we have the presumption of illegality of published content.
Oh, great. Thanks very much for that update. And just wanted to ask Agnieszka whether you have had any reaction or updates based on the case that you described to us, or whether you think that any such actions are needed.
Thank you very much for this question. Actually, the issue of internet service providers liability is considered to be one of the most important and one of the most difficult issues, because there is one thing, it is the matter of the balance of interest, different interests, the freedom of expression, the freedom of speech, the freedom of business, the different values, and they need to be balanced properly. And when we were talking, because since 2020 we have the specialized IP divisions in the courts, and there are some procedural rules dedicated for the these IP divisions. There were, during the legislative proceedings, we had a discussion if we need a more specific measure, because in fact the liability is based on civil law, mostly on civil law, and is supplemented by these legal provisions that comes from the European law, like this Article 14 of e-commerce directive. But generally, probably it was the case, the consequence of the case I mentioned today, because there were some voices. Well, the court did it perfectly with these legal provisions. Do we need anything more? Because the court dealt with the case having only general rules and general provisions. So so far we do not have any, but we will see what the future will bring. Thank you.
Great. Thank you very much for that. And I understand that there is a question for Richard, and that it's been sent to you perhaps in the chat. It is written in Latvian, so you would need to tell us the question and then your answer. And this will be our last question, then we'll wrap up and go back to the moderator. So please.
Yes, I received a question whether the violating sites were in the LV domain area. If yes, what would be the opinion of the Supreme Court what concerns the blocking of the domain if it was registered in another area but available in Latvia? I have to say that the domain area was in this particular case was beyond even the EU. That was the answer to the first part of the question. I cannot speak on behalf of the Supreme Court, but my personal opinion is that I do not believe there would be any obstacles to apply this obligation, this injunction, if there are specific grounds to do that, even if that is beyond the Latvian jurisdiction. That's why we actually need this protective measure, since quite often it's difficult to access such violating sites in exotic countries. And this particular site was, I believe, in Somalia. Of course, it's clear that the owners of the right should have this opportunity. But still, we have to comply with the proportionality principle. And of course, sometimes the side doesn't cooperate, like in the Pirate Bay case, you know, they openly claim that they want to distribute pirated content. And then in this case, for example, the evidentiary basis is quite small, the evidentiary basis that is required. But then we also have to be, we should avoid blocking sites where the most content is legal. And if such cases ended up in the Supreme Court, we would try to inform the courts how specific cases should be heard, because the sites really differ. We sometimes see that the site is really a violating site with pirated content, or there could be some maybe legal business where there's just one or two infringing works, and the holder of the site is not informed. I have also seen in YouTube that you can see, for example, the content that is placed there without the permission of the rights holder, and the posters find ways to get around the algorithms and post this illegal content. And this is just, you know, an example of what can take place.
Thank you very much for that. And of course, getting into the whole YouTube example would be another panel for us, I think, but an interesting way to conclude. We've heard a lot from our three distinguished panelists about considerations to be taken into account when thinking about blocking injunctions, proportionality, freedoms, balance. All of this comes into play. So thank you all for a really interesting discussion and for making the effort to kind of join the issues so that we got some interesting comparison going here. This has been a really interesting panel, and I thank you all very much. And now we'll turn back over to our moderator, Dacia Liberte, to close the program. Thank you.
Thank you to the panelists. Now we have reached the conclusion of the seminar. I would like to say thank you to all the presenters for the efforts in preparing their presentations, as well as to the participants for their desire to find out new information, for listening, for asking questions. On behalf of the Patent Board, I would like to also say thank you to the WIPO and EUIPO for their support in organizing this seminar. Also, thank you to the interpreters. to the technicians who made sure that we can be streamed online, as well as to colleagues from the patent board who invested a lot of effort to organize this event and for the event to proceed smoothly. And at the end, some practical aspects. We would really appreciate if you could provide feedback about this seminar, because your opinion is very important. And now you can use a Slido app. I hope that you see the link to the feedback questionnaire in English and in Latvian. You will receive the link also by email together with the presentations. Thank you again to everyone, and let us meet each other next time in person, hopefully.